Welcome back to the Deep Dive. Today we're taking on what at first glance might seem like a bit of a paradox.
It definitely sounds like one.
We're going to try and find the single core ethical thread that connects two completely different worlds. We're talking about a legal principle that bridges 13 centuries.
Right. We're jumping from the very beginning of the judicial system in 7th century Medina all the way to the very complex constitutional law of 20th century India.
It's a huge leap, and our mission today, for you listening, is to really unpack the sources that bring these two moments together. We're putting them side by side.
We have the judicial ethics of the Prophet Muhammad in, well, what was essentially a city-state, and we're comparing that with this massive landmark 1978 Indian Supreme Court case.
Maneka Gandhi versus the Union of India. And we're looking for that shared truth, that timeless idea about liberty and fairness that somehow, stays constant.
I think it's a deep dive that completely reframes how we think about a concept like due process.
Yeah.
We tend to assume these are modern Western ideas.
Right, something from the Enlightenment.
Exactly. But what the source material shows is that this demand for human dignity, for a fair process, it's ancient and it's universal. It's not tied to one geography or one period in time.
So at the heart of all of this, the whole conversation today is one single question. It's maybe the most fundamental question a citizen can ask their government.
And it is.
Can the state ever take away your life or your liberty without giving you a just and fair hearing? Does it have to stop and explain itself?
Or can it just act? Based on its own authority, its own power written down in some law book.
That's the challenge. And the material we're working with today, it lays out this unbroken line, this lineage of procedural fairness. It's not just about the outcome of a case.
No, it's about the structure. It's about how authority is required, ethically required, to treat an individual. That's what we're digging into.
Okay, let's start at the beginning then. Let's set the scene in 7th century Medina. This is such a critical moment in history.
It really is. You have a society that's in a state of massive transition.
You've got these old tribal customs, right? Where justice is often about vendetta, about community honor.
And swift. Very swift. The focus is on immediate restoration of balance, not necessarily a meticulous search for truth.
And that's all being shifted toward a structured legal system, one where laws are supposed to apply to everyone equally and be guided by a higher ethical principle.
That transition is absolutely key to understanding this. In a tribal system, if community consensus is strong, the standard of proof can be, pretty low.
Right. An accusation can be enough.
It can be. So to introduce a system that's based on verified proof, on the individual's right to be heard, that's not just a change. That's a legal revolution.
So our source material takes us to a very specific case. A man is accused of theft.
And theft. In a small growing community where trust and resources are everything, that's not a minor charge. It's a serious accusation.
So the case is brought forward, and you can imagine the momentum, the public pressure, probably pushing for a quick, decisive punishment.
And this is the pivot point. This moment isn't just about judging this one man. It's about establishing the process by which all judgments must be reached. It's about consciously overriding that ingrained traditional haste.
Because the instinct of a new state might be to make an example of someone, right? To deter crime through swift, harsh punishment.
Of course, stability is the priority. But here, the focus immediately shifts from the state's need for order to the system's need for fairness. It's a focus on protecting the accused.
So the proceedings are moving along, and then everything stops. There's this crucial pause, what our sources are calling the due process inquiry.
The Prophet himself halts the proceedings. Think about that. That's an act of immense judicial restraint.
He isn't questioning the community's right to be angry or to bring an accusation.
No. He's questioning the fairness of the process that has brought them to this point. And this is where ethics get baked into procedure.
Let's go through the questions he asked, because they're the bedrock of every fair legal system in the world today.
They really are. They're simple, but they're incredibly profound. First, he asks, has anyone verified the accusation?
Okay, so that's the burden of proof right there.
It's the absolute mandate for it. It demands facts, not just suspicion or rumor. It puts the onus on the accuser, not the accused.
Then the second question.
Were witnesses heard? This establishes the right to confront your accusers, to test the evidence. Is the story credible? Who saw what?
It's about transparency.
Completely. And then the third question, which is maybe the most critical for the dignity of the individual.
Was he given a chance to explain himself?
The right to be heard. In legal terms, audialtarum partem, hear the other side. It sounds so basic, but entire tyrannies are built on ignoring that one question.
So in that pause, what's discovered is basically haste, procedural negligence?
Yes, there was suspicion, there was an accusation, maybe even public anger, but there was no verified proof. The legal process was fundamentally incomplete. They were rushing to a conclusion.
So the proceedings are stopped, not because the man is proven innocent, but because the process itself failed. It wasn't fair.
Exactly. And it's out of this failure, this pause, that we get the great philosophical declaration that defines the entire system. It comes from a collection of hadith, Sunan al-Tirmidhi.
The statement that becomes the foundation for this entire concept of mercy and justice.
Yes. The declaration is, it is better for the ruler to err in forgiving than to err in punishing.
Wow, just think about that. It places this incredible ethical burden on the person in power. It's saying if you're going to make a mistake, and you might make it on the side of mercy.
It completely flips the script. The primary goal of the legal system is no longer just punishment. It's the avoidance of wrongful harm.
The dignity of the individual is placed above the state's desire for retribution.
And that's why this is the earliest form of procedural due process. To live up to that maxim to err on the side of forgiveness, you must have a strict process. You must have a high standard of proof. You must listen to witnesses. You must hear the defense.
The process is the safety net.
The process is the safety net that ensures compassion is the default. It forces that institutional hesitation. And that became the standard. Justice must protect first and only punish as a last, verified resort.
That's an incredible anchor point, a principle of judicial restraint from 13 centuries ago. But of course, the challenge for modern states is how to translate that ethical pause into hard, enforceable law that can stand up to a massive government bureaucracy.
And that is the perfect transition, because that's exactly what brings us to the constitutional crucible of 1970s India.
Right. We're making a huge jump now to New Delhi in the late 1970s, and you just can't understand this case without understanding the political atmosphere.
It was thick with the memory of constitutional failure. We have to talk about the emergency.
We do. For anyone who doesn't know, from 1975 to 77, India was under a state of emergency. Democratic rights were suspended. Constitutional guarantees for all practical purposes were gone.
State power was absolute and unchecked.
Yeah.
It led to, terrible abuses, politically motivated detentions, censorship, a total erosion of public faith in the system that was supposed to protect them.
So when democracy was restored, there was this intense period of reckoning, especially in the courts.
The judges had to ask themselves a very hard question. How did our Constitution, which is supposed to be so robust, allow this to happen? How could the state just strip citizens of their rights so easily?
Even when there were laws in the books allowing it.
Especially then.
Yeah.
They realized they needed to build a firewall, a way to structurally prevent the state from ever becoming that arbitrary again.
And this national trauma, this legal reckoning, it leads us directly to the Maneka Gandhi case. So let's talk about the specific incident that lit the fuse.
It was, on the surface, a simple administrative action. Maneka Gandhi, a journalist, had her passport confiscated by the government.
It's taken away.
Yes, revoked under the Passport Act.
Yeah.
But the key was how it was done. There was no explanation, no prior notice, no hearing, just a letter saying, hand over your passport.
And the government's defense was, frankly, kind of audacious.
It was. Their argument was, look, the Passport Act gives us the power to do this in the public interest. We followed the procedure in the Act. Case closed.
That one action taking a fundamental document needed for liberty and movement without any reason, without a hearing, it's the perfect example of arbitrary state power.
Which is why her challenge to the Supreme Court became so powerful. She wasn't just asking for her passport back. She was asking that same question from 13 centuries earlier, just in modern constitutional language.
Can you take away my liberty without fairness, without giving me a reason? Is having a law on the books enough, even if that law is unfair?
To really get the bombshell nature of the court's answer, we have to look at how they used to interpret the Constitution before this case. Specifically, Article 21.
The right to life and personal liberty sounds pretty straightforward.
You'd think so. But for decades, based on an old case called A.K. Gopalan, the court's interpretation was incredibly narrow. It focused on that one phrase, procedure established by law.
Okay, what did that mean in practice?
It meant that as long as Parliament passed a law, any law, and the government followed the literal steps written in that law, Article 21 was satisfied. The courts wouldn't look into whether the law itself was fair or just or reasonable.
So, if a law said the government can take your passport on a Tuesday if they feel like it, and they took it on a Tuesday, That was constitutional.
That's a crude way to put it, but yes, that was the problem. It was a formalistic, box-ticking exercise. It completely separated the idea of law from the idea of justice.
It's what allowed for all those abuses during the emergency. The government just passed laws that gave them arbitrary power, and the old interpretation of the Constitution couldn't stop them.
Precisely. But then came Justice P.N. Bhagwati and the bench in the Maneka Gandhi case. And they didn't just reinterpret the law. They basically redefined the meaning of liberty in a democracy.
How did they do that?
They looked at Article 21 and said, the right to life and personal liberty is not a mechanical phrase. It's not just a procedural hoop to jump through.
It has to mean something more.
It has to. Justice Bhagwati wrote that this right is a promise of fairness, reason, and dignity. That one sentence changed everything.
Because it injects a moral requirement into the law. The state can't hide behind a badly written or unfair law anymore.
Exactly. The judgment created a new rule. Any procedure that takes away liberty must itself be just, fair, and reasonable. The procedure has to pass a moral test.
So they basically imported the American concept of substantive due process into Indian law.
They did. They moved the system from asking, is there a law, to, is the law itself fair? So going back to your example, if the government has a law that says we can take your passport whenever we want.
The new court would say, yes, that's a procedure established by law, but it's an unreasonable and unfair procedure, so it violates Article 21.
That is the revolution. It turned Article 21 from a passive shield into an active sword, guaranteeing humane and fair treatment from the government. It forced the state to justify itself.
It's like that ethical pause from Medina was finally written into enforceable 20th century constitutional code.
It absolutely was. But the way the court did it was, frankly, a work of legal genius. They didn't just change the meaning of Article 21 on its own. They wove it together with other fundamental rights.
And that's what created this so-called golden triangle.
That's it. And we have to break that down because it's the architectural blueprint for how to protect liberty in a modern state.
Okay, this brings us to the real engine room of this deep dive, the creation of this golden triangle. It's a bit complex, but it's the mechanism that makes the whole principle work.
It's the legal engineering, yeah.
Yeah.
The court had a problem. How do we make sure every law is fair without just letting judges strike down any law they don't personally like?
Right. How do you avoid judicial overreach while still preventing legislative tyranny?
The answer was to create a linked three-part test. They fused Article 21, the right to liberty, with two other powerful rights that were already in the Constitution.
Those are Article 19, which guarantees fundamental freedoms, and Article 14, which guarantees equality before the law.
Let's break those down. Article 21 is the right that's being impacted. Your liberty is at stake. Article 19 covers specific freedoms, like speech or movement, and says the government can only restrict them with reasonable limitations.
And Article 14 guarantees equality, but the court gave it a new, powerful interpretation.
A massively powerful one. They said Article 14 is a guarantee against arbitrariness. An arbitrary action is, by its very nature, an unequal one.
I want to pause on that because it's a key intellectual leap. How does acting arbitrarily violate equality?
Think about it. Equality means the laws applied with reason and consistency. If the government can act on a whim, without a standard, without a principle.
Then it can treat one person differently from another for no good reason.
Exactly. If they can take your passport based on a secret whim but not someone else's, that is the opposite of equality. Arbitrariness is the enemy of equality. They are mutually exclusive.
So before this case, these three articles, 14, 19, and 21, were seen as separate silos.
Completely separate. A lie was tested against one, and if it passed, that was it. Maneka Gandhi smashed those walls down.
And created a single, unified test.
Yes. The new rule is this. Any government action that touches your life or liberty under Article 21 must also pass the tests of reasonableness from Article 19 and non-arbitrariness from Article 14.
It has to clear all three hurdles.
All three. If it fails even one, it's unconstitutional. The procedure is not just, fair, and reasonable, and therefore is not due process.
Well, let's apply that to Maneka Gandhi's case. Her passport was taken.
Okay, so that action clearly affects her personal liberty under Article 21. Now, does it pass the other two tests?
Well, was it reasonable under Article 19? She wasn't given a reason or a hearing, so she had no chance to defend her freedom of movement. That seems inherently unreasonable.
It fails test one. Now for test two.
Yep.
Was it arbitrary under Article 14? The government gave no reason, no standard, no justification. It was a very definition of an arbitrary act.
But it fails test two as well.
And because it fails both, The procedure used is not due process, and therefore the action is a violation of Article 21. The legal loophole is sealed.
This is the constitutional architecture that forces the state to do what the prophet insisted upon 1,300 years earlier: to pause, to verify, to listen, to justify.
It's an incredibly robust system for judicial review. The court is no longer just asking, did you follow the steps in the law?
It's now asking, is the law itself and the way you're applying it fair?
And that's the shift that constitutionalized human dignity. It's no longer just a nice idea in the preamble. It's an enforceable legal right with real teeth.
Okay, let's connect the dots now explicitly, using the data from our sources to bridge the two eras.
In 7th century Medina, the requirement was clear: verification, hearing, and fairness before any punishment. The guiding ethic was better to err in forgiving.
A system based on judicial restraint to prevent wrongful harm.
Now jump to the 20th century. The requirement established by Maneka Gandhi is fairness, reasonableness, and non-arbitrariness, all mandated as part of due process through the Golden Triangle.
A system based on constitutional architecture to prevent state overreach.
But the philosophical goal, the destination, is identical. In one, justice is rooted in compassion. In the other, it's rooted in constitutional morality. But both are about protecting the individual from the raw, unchecked power of the authority.
The ethical thread is just seamless. It doesn't matter if the authority is a single ruler in a small city or a massive modern bureaucracy.
The core logic, the ratio decidendi, as lawyers would say, is the same. And it's a powerful one.
Which is?
The protection of dignity and due process stands above authority for law. Without fairness is tyranny.
Whether that fairness comes from a judge's ethical commitment or a constitution's structural command, the moment law is divorced from fairness, it stops being justice.
It just becomes oppression with a rule book. The 7th century pause is the direct ethical ancestor of the 20th century Golden Triangle. Both are designed to do the same thing: make power respect the person.
And this incredible legal innovation, this Golden Triangle, it didn't just stay within India's borders, did it?
No, not at all. It became a hugely influential legal export, a powerful idea that traveled.
Let's talk about that, the global impact, because that really speaks to the universality of this principle.
Right, so what you have is this model. The Prophet-Seer approach introduced this foundational concept of procedural due process. The process must be fair and must precede punishment.
It sets the ethical standard.
Then, 13 centuries later, Maneka Gandhi constitutionalizes it. It provides a modern, secular, legal roadmap for how any judiciary can limit state power.
And this is how constitutional ideas often spread, isn't it? A major court in one country comes up with a powerful, well-reasoned judgment.
And judiciaries in neighboring countries, especially those with similar legal traditions or facing similar problems, they take notice.
Our sources point specifically to Pakistan and Bangladesh as places where this thinking took root.
It makes perfect sense. These nations have a shared colonial legal history, and they were all grappling with the same fundamental tension: how to balance state authority with individual rights in a post-colonial context.
And the Maneka Gandhi judgment offered a solution that was, homegrown. It wasn't an import from the West. It was a South Asian solution to a universal problem.
Exactly. Let's look at Pakistan, where the influence is really concrete, and you can see it written right into their constitution.
Okay, which specific articles reflect this shift in thinking?
The due process doctrine from Maneka Gandhi really becomes the intellectual foundation for Articles 4, 9, and 10A of the Pakistani Constitution.
So let's break those down. What does Article 4 say?
Article 4 is about the right to be treated in accordance with the law. It's very similar to the non-arbitrariness principle that the Indian Supreme Court found in their Article 14. It establishes that the state must act lawfully, not on a whim.
Okay, and Article 9?
Article 9 is Pakistan's direct equivalent of India's Article 21. It says no person shall be deprived of life or liberty except in accordance with law.
But there's that same potential trap, right? That phrase, in accordance with law, could just mean following the written text of any unfair law.
Exactly the same vulnerability that existed in India before 1978. And that's why Article 10A is so critical. It was added later, specifically to close that loophole.
What does 10A do?
Article 10A explicitly guarantees the right to a fair trial and due process. That addition is everything. It forces the Pakistani courts to read the guarantee of liberty in Article 9 through a new lens.
The lens of substantive fairness.
Precisely. The law itself now has to be just, fair, and reasonable. They effectively import the entire philosophy of the Golden Triangle. It requires the law to have that moral content.
So they internalize that core lesson. The state has to pause. It has to be fair. It can't just rely on its own power.
That's the essence of it. And we see similar judicial reasoning in Bangladesh, where their Supreme Court has also cited this line of jurisprudence to protect fundamental rights against arbitrary state action.
It's just amazing that simple ethical demand for verification, for hearing from the 7th century, it survives all that time, navigates all that political change.
And gets translated into binding constitutional language of modern nation-states across a whole subcontinent.
Which brings us back to the final moral conclusion that our sources draw from all this. It feels like the perfect summary of the whole journey.
It is. True justice does not rush to punish. It pauses to understand.
That pause,
Yeah.
that's where dignity lives. When the state stops, when it listens, when it has to justify itself, that's when it acknowledges the humanity of the individual. It acknowledges that the cost of getting it wrong, of punishing an innocent person, is just too high.
And that reinforces the final point. In every era, mercy guided by fairness is the highest form of law. It doesn't matter if the source of that fairness is a religious ethic of compassion or a secular constitution built from a democratic crisis.
The goal is the same. Protection, not just punishment. That's the line between a just society and a tyranny.
It really is. The Maneka Gandhi decision didn't have to invent the idea of fairness. That idea was ancient. What it did was invent a modern legal mechanism to force a giant impersonal government to comply with that ancient ethical demand.
The Golden Triangle is the 20th century enforcement mechanism for that 7th century truth. A structure built to make sure the state can never just legislate its way around fairness.
Absolutely. A brilliant summary of the whole thing.
Okay, so as we wrap up this deep dive, let's try to distill this all down into the 2 essential nuggets for you, the learner, the key takeaways that should really stick with you.
All right. I think nugget number 1 is this. Due process isn't some modern technical legal invention. It's a timeless ethical demand for human dignity.
We saw its roots in the 7th century, with that non-negotiable requirement for verification for a hearing and that guiding principle. It's better to err on the side of mercy.
That established judicial restraint, that pause, as the highest virtue of power.
Okay, that's nugget 1. What's number 2?
Nugget 2 is how modern law makes that ancient principle work. Modern constitutionalism, and we use the Maneka Gandhi case as the perfect example, operationalizes this demand for fairness.
It does it by building a structure, this golden triangle, that fuses the ideas of equality, freedom, and procedure.
Right. And that legal mechanism ensures that any action the state takes that impacts your liberty has to be justifiable. It must be reasonable, it must be fair, it can't be arbitrary. It translates that old idea of compassion into enforceable modern law.
So the core principles are eternal, but the tools we use to defend them have to evolve to match the power of the modern state.
That's a great way to put it. But before we sign off, let's leave you with one final thought to take with you.
Okay.
We've been talking this whole time about courtrooms and constitutions, high-level formal settings where these protections are supposed to be guaranteed.
Right.
But think about how this principle, this choice between rushing to punish and pausing to understand, applies in all the other places where power is exercised.
You mean outside the legal system?
Exactly.
Yeah.
Think about a company's internal disciplinary process, a university's student conduct board, or just, any large administrative agency making decisions that affect people's lives and livelihoods.
These are all places that have huge power over individuals, but they aren't courts.
They're not. So the question to you is, what checks and balances exist in those systems? What mechanisms are in place to ensure they pause to understand, to verify, to give the person a real chance to be heard, instead of just rushing to a decision for the sake of efficiency or authority?
The principle of dignity should apply everywhere, but the Golden Triangle usually doesn't.
And that ethical pause is something we have to demand in every context, not just from our governments, but from all institutions of power.
Something to think about. Thank you for joining us on this deep dive.
We'll catch you next time.